Shut up. Harry trembles as Judge Martin tore up a lawsuit after using His Royal Highness in security court, just Harry. At the defense hearing with the Home Office, Harry proclaimed himself a prince, which infuriated the judge because he was legally stripped of that title. He thinks he did it on purpose to pressure him to win. That's why Martin ripped off the lawsuit because it violates English law and respect for the king. Prince Harry is being criticized for using HRH titles and his legal name in court after the Duke of Sussex lost his legal bid to challenge the British government's refusal to let him pay for his own police protection when he's in the UK. King Charles Younger's son was stripped of the police security usually afforded to royal figures in the UK after he and his American wife Meghan stepped down from their official roles in 2020. The High Court in London last year already agreed that he should be allowed to challenge the original decision to end his protection, but on Tuesday it rejected his bid for a second court review over the rejection of his offer to pay privately for the highly trained officers. The court verdict sparked debate on the royal title and the name Harry used for himself in his legal battle. Some people called him fake for identifying himself as His Royal Highness the Prince Henry Charles Albert David instead of using his nickname Harry. But his critics seem to be unaware of the fact that using full names in court documents is not something weird, other than Harry using the HRH title after the late Queen banned him and his wife from using it. The fact is, the Queen did not want him to use the title for profit, but it's fine to use the title in the court documents. In the judgment issue last year, when the Queen was still alive, Harry was identified as the Duke of Sussex instead of His Royal Highness. The decision to remove publicly funded security was taken by Ravec, which approves security for the royals and VIPs, such as the Prime Minister. Last week, lawyers for Harry had argued that Ravec did not have the power to reject his funding offer, and even if it did have such authority, it was wrong not to consider an exception or hear representations on his behalf. Ravec had argued that public confidence would be undermined if it were believed that a wealthy individual could pay to receive protective security measures that they would not receive if they were less wealthy. It said allowing private funding would also reduce the availability of a limited specialist resource in cases where it was deemed to be in the public interest. On Tuesday, in a written judgment, Mr. Justice Chamberlain refused Harry permission to bring a judicial review over that decision. Among the grounds argued by the Duke's lawyers was that it contradicts Section 25(1) of the 1996 Police Act, which allows the chief officer of the police to provide special services subject to payment. But Chamberlain wrote, "In my judgment, the short answer to this point is that Ravec did not say that it would be contrary to the public interest to allow wealthy individuals to pay for any police services. It can be taken to have understood that Section 25(1), to which it was referring to, expressly envisages payment for some such services. Its reasoning was narrowly confined to the protective security services that fall within its remit."